then. But please continue on with your food, and there'll be more discussion later on. So that was the case of Mistrina, which anyone can go and sort of look up. And there's another one with Actron, case in Queensland. And this was dealt through the Queensland Court of Appeal. So it went through the Supreme Court, and then went back to the Court of Appeal. This didn't go any further, but as I say, High Court is the next stop after this one. So in this case, DEQ Consulting issued defective certifications regarding design and construction compliance. So they were designing the building. They were also involved with inspections, and then inspections which both vouched for conformance to the design and compliance with the regulation, the building regulations. Okay, what's the problem here? So Actron. Actron was the purchaser. DEQ was contracted to the builder, DDS, project management. So again, another case where the appellant and the respondent had no contractual relationship between them, and that was irrelevant. Okay, so DEQ worked for DDS, but Actron was actually pursuing DEQ consulting engineering. This was for a slab on ground, what we just in the industry call an SOG, slab on ground, similar to the one we saw before with Mistrina. That was just an almighty slab on ground. So it's a slab on ground for a warehouse, industrial warehouse. And in this particular case, so DEQ, working for the design and construct builder, provided them with 3 design options. Okay, all with varying levels of intended performance, varying levels of construction cost, of course. And then DDS made the choice as to what they want. Well, did they choose the best one? Did they choose the one that would do everything? No, they just choose the cheapest out of the 3, which is what they did. Okay, and in this case, you look at one of these articles written by a legal firm, the summary articles, they don't go into the detail. I actually read through the judgment. It's actually excellent. They cover a lot of detail, and they actually got extracts from the engineer's actual notes from the drawing and his report, where he actually explained all the pros and cons of all the 3 options. He explained the whole lot, said this one will do this, it's got this level of performance, blah, 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 all cited in the judgment. This one was the shorter judgment of the 2, it's only 18 pages. This is actually a good one to go and find and actually have a read of. So anyway, so in Queensland, so I showed those 2 certification forms earlier on relating to Victoria, Regulation 126. Well, in Queensland, they call it Forms 15 and 16. So those are their compliance certifications under their building regs. And so Form 15 is for design compliance. Form 16 is for construction compliance. Similar sort of thing, you have to cite the building regulations that you're actually complying with. You might list the drawings, but the drawings flow out of being compliant with the regulations. So this is always referring back to the regulatory environment. And so it's both a compliance and a conformance. So it's not only that both the design separately and the construction separately complied with the regulations, but that they also vouched for the conformance of the construction back to the design as well. Okay, so Actron bought the warehouse completed from the previous owner, still relatively new, and they decided they needed an operation which was going to involve putting in pallet racking, massive settlements in the building. And so not just settlements, but settlements, what we call differential settlements. If we just had uniform settlements in structures, life would be a whole lot easier. But what you get typically is differential, different things in different locations moving in different amounts and at different rates. So you got mighty tall pallet racking, and it also starts doing this, and eventually and actually steps through the slab joints. So it ended up being the warehouse is actually unusable. Forklifts would run around and actually be bashing into steps in the concrete. Your pallet racking would actually be leaning over. So it actually was deemed to be totally unusable. So it could not function. Its utility as a fairly unremarkable warehouse with pallet racking, not a big deal, completely stuffed. They couldn't do it. So this was the problem. So it became unusable. And so So Actron went after a lot of parties. A lot of parties settled earlier before it went to trial, but then it pursued DEQ. And so in the initial case, the misleading and deceptive conduct wasn't actually found, but it certainly came up at the Court of Appeal. So that's what they actually found. And it was over the certification. So DEQ certified that the design and the construction complied with the, as they call it in Queensland, this term here, the Standard Building Regulation 93, which in turn then refers to the National Construction Code, which in turn then refers to AS 3600. Okay, and the key term on which it all hinged, this is straight out of AS 3600, 2001, long time ago, was that what is designed has to offer performance without undue differential or uniform settlement. And a lot of argument hinged around what do those terms of undue, what does undue actually mean in terms of who is it for? Now, in terms of the original client, whom DEQ worked for, DDS and the original owner of the building, they just were building it just to sell it on to someone else. But one of the key points out of the judgment was that DEQ or any engineer, designing engineer, you're not just to take into account what the expectations of your current client are, because there's nothing on the Form 15 that says that this complies with what the current client's expectations are. It actually says it complies with the regulation. So even if the current client might only, perhaps they want to just put hay bales in there, doesn't really care where it moves. But if you are building a warehouse for which, say, they might want to only put hay bales in there, you have to think this is a warehouse. There's actually a lot of background information in the judgment about this, saying they actually said it was for storage to a certain height. There were actually words given to, guidance about the typical warehouse operations, which the original owner wasn't doing, but it was certainly open to be applied that they ought to have taken into account the consideration of high-load forklifts, which was actually written in the brief somewhere, and also they're going to have pallet racking there, so the building didn't perform. There was actually highly reactive marine clays underneath the slab. So both through swelling and shrinking with changing moisture content, which is a problem we get with reactive soils in foundation design, but also there was the swelling and shrinking with moisture conditions, but also the loads applied. And so you get all these different settlements all over the place, and so the building was used sort of not useful at all. And honestly, it seems to be a really fine line. This is a very good judgment to read. A very fine line between what you think, well, the engineer actually, he spelt it all out. He gave them the three options. He told them the pros and cons for each. He actually predicted the sort of settlements they might expect for each of the three options. But the judgment found it's not for the client to decide what's the appropriate design. You are the professional engineer. It's your job to exercise your professional judgment that it complies with the requirements of regulation. And that's what really sunk him on that.
It seems as though the form is wrong. The form should say it complies with the client's requirements.
No.
It should.
No, compliance is about regulation. Look, it'd be nice to think it just complies with that client. You have to think about not only just the client today. If that client's got really soft requirements, really soft expectations, doesn't really want to do, all he wants to do is just park a tractor in it. That's not the point. So you need to know and apply what's in the regulations. That is what you are certifying. That is the point here. Yeah, quick question, yep.
Yeah, are you saying?
Sorry, the one in the middle. Sorry, you first, yep.
Are you saying some of the options didn't right?
That's right, the first two. The builder chose the cheapest one, number one. Number three, the designer, well, he's probably leaned on to give me a couple of options, mate, and I'll choose one. Of course, he chooses the cheapest. He even predicted typical settlements he might get out of that one. And in fact, the settlements that they got, after they got expert engineers involved for the forensic investigation afterwards, the settlements they got were actually within the band that he predicted for option one. So his engineering was actually good.
It seems that the lawyers have got control of the situation.
No, this isn't the lawyers, Frank.
The lawyers and the government, or the regulators.
Well, this is about protecting the public.
So what do they consider?
But if you build what the client wants, isn't that your responsibility?
No. This is This is the point. When we certify, it is not about the standard. It is not about what the client wants. Yes, if they want more, fine. But as an absolute minimum, whether someone asks you to design to regulation, in this case for buildings, to the NCC or not, or whatever other regulations operating in your engineering discipline, no matter what the client says, if they're asking for less than what the regulatory bottom level is, you have to pull them up to that level there.
So you should walk away.
Yes, and say, if you're insisting that I do this, then I'm out of here. That's really the best thing to do. Now, heaps of questions. I'll run through these last few slides because I'm sure there's going to be a lot of discussion coming up.
He's predicted failure, and he's put that in writing.
Yep.
The client's then chosen failure, and he is held accountable.
Yeah. To finish the build, brand new, sell it on to someone else who actually used it as a warehouse.
But he has said it's not going to work.
He advised him. The point that I'm saying is, and I'm reiterating, and this is, and again, it was news to me when I first got my head around it, it might be news to you, is that certification is about regulation. It's not about what the client wants. It's not about what the Australian standard says. Okay? You need to know. And if you're working in the building space,
The outcome you're saying.
well, the outcome would be looking at the compliance of the outcome back to the regulation again. And again, this actually hints. So this is actually an interesting case for me because it was in this particular case where they make multiple references back to an Australian standard. This is the last point I wanted to point out, or just the last bit of blood and guts here. So the Court of Appeal judgment didn't deal with the remedies for it. That was referred back to the initial trial judge. But the rectification cost for that warehouse was $1 million. So obviously that was on the table to be discussed. The DEQ director was struck off from being a registered professional engineer in Queensland and just retired. He just pulled the pin, he couldn't operate anymore. So that was him. So this is the really point I want to make here. So this is a revision back in 2001, AS 3600. I'm actually on the standards committee for this standard. So I'm pretty intimately acquainted with this and interested in this. This is actually a quote out of that standard in 2001. When they revised the standard in 2009 and they revised it again in 2018, and we're just about to revise it again this year, this wording has actually been dropped out, but not anymore. So I think the Standards Committee got a bit of a shock when someone started saying, well, actually, there's a Queensland Court of Appeal judgment which is actually talking about this particular provision from 25 years ago, and I think it should be back in there. Well, that's what's going to happen. So for those of you who are interested in 3600, the public comment period starts soon, and this particular wording is going to be back in there in section 20 something or other.
So should we not define undue?
Well, a lot of discussion by the judge actually what undue. So undue then comes back to what a typical, reasonable use. It was an industrial warehouse. Okay? And again, the judgment is very good because the judge actually spends a lot of time discussing these things. There's actually a lot less legalese in it than I expected. It's actually quite a readable document, so I'd encourage you to find that. So, and again, so this is a connection. So the certification was that it complied with the Standard Building Regulation 93. So that's Queensland legislation, which in turn sends you off to the National Construction Code, which in turn then sends you off to AS 3600. That's the point from that.
There's been some discussion in the Foundations and Footing Society about offering your client a really expensive footing, you won't crack your building, or a cheaper one that will, that the client chooses.
Yep.
I can't afford it, but I don't.
That is exactly the point the judge made here, is that you do not abrogate your design responsibility to a client to make that decision. If the options you are providing are both above the minimum level that the regulation would provide, fine, let him choose. But you can't offer the client two options, one which is sort of above and below the bar, and say, it's over to you, mate, and I've told you all the things about it, which is what this guy did. It looks on paper like he actually did a really good job, but that's not how it worked out. So anyway, I'll push through the last of these quickly.
The design is okay, the certification becomes the issue.
Well, that's what this was about.
Yeah, absolutely.
And it was the defective certification, and it was deemed to be misleading and deceptive conduct under the ACL. And that's what sunk them both in both these cases. So again, back to the ACL. Some of the offences in there may be criminal. Okay, and I've listed a couple of there. So some we've heard of, cartel conduct is always criminal. Very, very serious. Misleading and deceptive conduct is listed there. Breach of consumer guarantees, the ones we mentioned before, but from which engineers and architects are exempted. Breach of product safety rules, unsolicited consumer agreements. They can actually be deemed to be criminal offences under the ACL. But this is the point I want to make here.
Solicited.
Unsolicited consumer agreements. This is the one that some of these in the Financial Services Royal Commission, a lot of these people selling, prepaid funeral products to remote Aboriginal communities and sort of ripping the guts out of them for many, many years, hounding them. I think a lot of them fell foul of that as well. Mm-hmm.
Sorry, that's still unclear for me. So it's still a bit unclear for me. The answers.
Well,
And marketing product.
yes, people pushing you, engaging you, enticing you into consumer agreements, all your phone plans, all that sort of stuff. Okay, not really the sort of thing we get involved in, but I'm just trying to say that in the list of things that can be criminal, misleading deceptive conduct, which was the hinging point on those two cases, and this is the important thing I want to make here, is that criminal acts and intentional wrongdoing are likely to be uninsurable, since it's contrary to what's called the public policy principle. You can't profit from such conduct, and PI will actually drop you for that. So you're on your own. And although it's not directly the same, but just to make you aware that in Victoria, there's actually a legal prohibition against insuring or indemnifying for OH&S penalties. So if a company or a director has been penalised for OH&S infringement, you can't shuffle that off to the PI insurer. And in fact, people offering insurance against that themselves will be prosecuted. So the offender will be prosecuted for that, and anyone purporting to offer insurance for that will be prosecuted. So this is this whole thing. So again, I mean, I studied engineering, you probably studied engineering, we didn't look at any of this, but this is all happening around us. And you just need to be aware. So as I say, you're exposed with PI cover. It's in relation to your PI cover if you fall foul of any criminal acts under the ACL. And also, moving on to this, I don't know how much time we get to talk about this, but being covered for PI is actually a prerequisite for your registration here. A few nods. So some of us have found this out already. So I'll move right along. So I've got only a couple more slides and I'll wrap this up. So here's just an example. So again, compliance is about regulation, not Australian standards. The Australian standards might be referred to in the regulation, but you start with the regulation first. Here's just an example from my world. Okay, the NCC requires more of concrete structures than is provided for by AS 3600. Now, I think that will be news to a lot of engineers, and in particular these three areas. These are the things I'm not going to talk about tonight in this other paper I'm doing. So in these areas of robustness, if you're a structural engineer, these things will tweak. Certainly the first one you'll recognise, but fire resistance design and also weatherproofing. There are things that the NCC requires that the AS 3600 doesn't really address, but when you certify, you're certifying to this, not to that. So if you've only designed to this, you may well have missed a few of the things that you're required to have certified from this. Okay, now just an example from abroad. Okay, this dives deep. So here's a slide from the last time I presented here. This is back in October 23. You might remember I did on this Rana Plaza collapse in Bangladesh, the deadliest accidental structural failure in history, modern history. Okay, this particular slide is not of that failure. This is one of the previous ones, which I said it's not this particular one. This is the failure that I'm going to be speaking about also at the conference. This is this one in Miami, at Surfside, Miami. Champlain Towers, 4 years ago, the whole building just collapsed virtually without warning in the middle of the night. Okay, so, but again, the point is, and the point that from all the preliminary work, and I'll be making the point in this particular paper coming up, is that it's actually through failures of robustness and weatherproofing. Two of those ones I mentioned on the previous slide, that's why this thing failed. Then amongst my other investigations, I've been trying to find out what were the American building codes like at that time, back in around about 1980, the early 80s. And so it's not easy. So these things matter. It's not just ticking boxes in standards saying you've covered these things, but they've got serious implications. So anyway, so that's the point. So yeah, so this particular one in Miami, that occurred in June 21. And that's what I present about it there. So that's just an example there. But again, I know obviously I'll sort of refer to things in my field, but I'm just hoping or saying that for all of us in our various disciplines, this model of certifying, finding what the regulations are, what are you actually saying that your things comply with? That's where you start, and then you see where you plug in Australian standards or client expectations around that. That's the method you do with this. Right, so now a little bit on Victorian registration. I think this is the last or second last slide. So for those of us who are engaged in the whole registration system here in Victoria with as professional engineers, since the Act came in 2019, just to make you aware that there obviously is an Act. Pardon me. There's a code of conduct that actually has been published. Consumer Affairs sort of hosts that, and you can get the information there about that. But just to make you aware that it's not unlike other codes of conduct, which they might just say this is guidance to assist you with how you might comply with something or other. You see that a lot in OH&S type legislation. But this one, just in that breach there, registered professionals must comply with this code. So if you want to know what you must do, for starters, you need to get a copy of this code of conduct to comply with the Act. And that's just the contents page out of it there, just for information. But look, it's all out there in public space, so you can find all that. So just to make you aware, so if you're engaging with if you are engaging with the professional engineer registration space, or perhaps you're wondering, I wonder if I'm supposed to be engaging with that to do what I do, and if you do, then this is actually part of what you've got to know about as well. Okay. So bottom line, last slide.
Was that produced by Engineers Australia?
No, Engineers Australia. Look, not only David Chandler, but from me, and I think from a lot of my colleagues here tonight, Engineers Australia is a bit of a joke. So don't really go looking for stuff from them. Right. So, do you want even the risk of legal exposure, even a successful defence, can set you back quite a lot, or the uncertainty of PI cover with certain actions? You can't afford to be ignorant of what you are supposed to do, what you are required to do in these things. And again, one more time, regulatory certification is about compliance with regulation. As in, when I say regulatory certification that is required by the regulations will be about compliance with the regulations. They're not spinning off to Australian standards, they're not spinning off to client expectations. And not with Australian standards per se, unless they are referred to within those regulations. Okay, there's a bit of a line you've got to put there. Building regulation is state law, right? But adoption of the National Construction Code. Okay, so there is a National Construction Code. It's the one document, but every state legislation appends that to its own building regulations. That's how that works. And the Australian consumer law is actually Commonwealth legislation that applies across the country. And again, the question for us all, do you need to be registered? And what are the conditions that apply? Conditions with which you then certify that you comply. So the certification process even applies with you actually getting your registration in the first place. So again, you can't afford to have false or defective certifications on that front. And really, really the bottom line, this is a good one to take away. When you certify, you claim to comply and others have a right to rely. That was the point of those two case studies. Other parties, not contractually related to the engineers themselves, suffered financial loss as a result of what they did. They relied upon their certification, and that was the basis of their successful claims eventually through the Court of Appeal. Right, that'll do it. So, we might take a couple of questions. 4:35. I'll do a couple of questions. I'm pretty sure I won't know the answers to a lot of them. Actually, probably there may be more answers from within the audience tonight for the questions that come up. So, you already had a go? Sorry.
Go back that previous slide.
Yep.
There's